Good morning this Monday morning. You're watching the Law and Crime Network. I'm here along with Stephanie Willis. And don't adjust your monitors. I am here first thing in the morning for a shocking change, right?
Right. I mean, I love having you here, though. You know, bright-eyed, bushy-tailed. It's great. It's great to have
I
you
have
here this morning.
a reserve of coffee here to keep me going through the morning.
Yeah.
So we've got a lot of things on it.
We do. We'll actually be discussing Oscar Pistorius's double sentence that was just received last week, if you all were not aware. That happened, I believe it was sometime late last week, either Thursday or Friday. We're also going to be discussing the Chris Soules hearing, so that should be interesting. Chris Soules was actually appeared on The Bachelorette and had his own season on season 19 on The Bachelor, so we'll be discussing that as well. And we have a great guest with us this morning. We have Jonna Spilbor with us. She'll be discussing the Oscar Pistorius matter with us.
Sure, well, good morning.
Yeah, thanks so much for being here with us this morning, Jonna.
I'm happy to be here. I'm usually up at this hour, so it's no big deal.
I'm glad that I'm up, I'm just not sitting
You're just not here.
Let's be clear.
Gotcha.
I am indeed awake by 9 a.m. I don't think I could function if I wasn't. I'm usually watching, not sitting here, though.
So what we have this morning is we have Oscar Pistorius. We know that originally there was so much that was going on in this case.
Oh my.
Oscar was convicted of murdering his 29-year-old girlfriend, who was a reality TV star and a model. And it was just kind of a whirlwind or world storm that happened after shooting and killing his girlfriend. We know that he came from the Olympics in Beijing, where he had a phenomenal feat, being the first double amputee to run in the Olympics, and then we have this. Jonna, tell us a little bit about it.
So he was a superstar, right? Nobody wanted, this case was so tragic and sad on so many levels, right? He's a superstar, he has a beautiful girlfriend. His basic defense in the trial was, it was a horrible accident. I didn't mean to kill her. I thought there was an intruder in the house. You know, where I live isn't exactly the safest place on the planet, and it was all a gigantic mistake. And the interesting thing that I thought this case illustrated was the vast difference between our system of justice and the South African system of justice. They couldn't be more divergent, right? They're very, very different. And so when that was a very lengthy trial. There was a delay because they don't have a jury system in South Africa, which is very interesting. But I think the assessor sort of split the baby. He got Oscar got a very light sentence, but it showed that they thought perhaps it wasn't an accident. So they sort of split the baby there. What we wouldn't have here is a prosecutor having an opportunity to appeal a sentence, but there they did, and now the sentence has been doubled. I don't know if that's justice, to be honest with you.
Well, I have to say, you were showing, or you were discussing the disparities between our system and the justice system in South Africa. One of the things that you stated was the fact that he's tried by a judge and not a jury. Right. The next thing is the fact that the minimum sentence there for murder is 15 years, and there's no death penalty there in South Africa at all. And so I know one of the things that the trial judge stated was the fact that she considered that there were mitigating circumstances, which allowed her to, I guess, come down with a sentence of 6 years. But apparently, something that we're not allowed to do here is appeal this sentence. What are you thinking about this, Aaron?
Well, I mean, I had to kind of dig into the background of this a little bit. In the legal system in South Africa is kind of a mix of Roman, Dutch, English, and then local custom. And so you have a system that's rolled together much differently than what we have here in the United States, where every state other than Louisiana is based on English common law, and then Louisiana is based on French law in a lot of ways. So it results in a system where, there's one charge, and then one person yanks back the lower charge that he originally faced, and then throws a harsher charge, and then you've got a lighter sentence, and then certainly a more harsh sentence. It's still not as harsh as it probably would have been here in the United States, but it's harsher than he originally faced.
Well, and I don't know if it would have been harsher, because here in the United States, the jury would have had to decide whether there was criminal culpability or not. And if they found that it was an accident, then he probably would have gotten a not guilty verdict and then no sentence imposed. So it's very strange the way they do things over there. Now my question is, and I'm going to look into this, can he now appeal the higher sentence, or is it done there?
Right.
Like, has it reached the equivalent of the Supreme Court of that land? I don't know.
Well, from my research, what I've seen is that he can actually appeal to what's called the Constitutional Court. The Constitutional Court is the equal or the same as the Supreme Court of the United States here. So he may have
And he can do that there. Wow.
He may have another shot. But what we're going to do is we're going to throw to the clip of Oscar Pistorius so that you all can take a look.
I would like to take this opportunity to apologize to Mrs. and Mr. Steenkamp, to Reva's family, to those of you who knew her who are here today. I'd like to apologize and say that there's not a moment, and there hasn't been a moment since this tragedy happened, that I haven't thought about your family. I wake up every morning, you're the first people I think of, the first people I pray for. I can't imagine the pain and the sorrow and the emptiness that I've caused you and your family. I was simply trying to protect Riva. I can promise that when she went to bed that night, she felt loved. I'm scared to sleep. For several reasons, but I have terrible nightmares about things that happen at night, where I wake up and I can smell blood, and I wake up to being terrified. If I hear a noise, I wake up just in a complete state of terror, to a point that I'd rather not sleep. I sought medical advice to start medication for sleeping.
And welcome back to the Law and Crime Network. What you just saw was Oscar Pistorius on the stand. He provided some testimony in regards to, I guess, some kind of a statement prior to his sentence being given to him by the judge. Just to provide you all with a little bit of a recap, what we know is that Pistorius was originally convicted of manslaughter by the trial judge in 2014. That conviction was then overturned and replaced with a murder conviction in 2015. Next, he was then sentenced to 6 years by the trial judge regarding the murder conviction, excuse me. Then the decision was then rejected recently by the Supreme Court, and so now we have him having to serve 13 years and 5 months. Jonna, let's talk about this a little bit. We were talking when the clip was on, the fact that it may be a little dangerous in South Africa.
Right.
But the thing that I wanted to talk about a little bit as well is the fact that he had some prior situations, I'll say, because he was never really convicted, and some of the charges were ultimately dismissed. We know that in 2009, he spent some time in jail after allegedly assaulting a 19-year-old at a party, and that was settled outside of court. In 2011, he was accused of firing a gun through a sunroof of his ex-girlfriend's moving car. The court found that there was not enough evidence to convict. And then in 2013, weeks before he shot Riva, his girlfriend, he discharged a gun by accident in a restaurant. Now, is this bad luck, or is this just someone who ultimately the law is catching up with him at this time?
Is this bad luck, or is he a bad boy?
Right.
Like, he did have, I guess he had a bit of a reputation as a hothead. And here, of course, just being a hothead probably wouldn't have entered into the picture at all, because it shows propensity, and that might have been evidence that would not have been allowed to come in. And I don't know how much if the assessor had his entire record in front of her, but I think it's a big leap, although it was made, to go from, well, he's a bit of a hothead, to he viciously murdered his girlfriend in the middle of the night while she was locked in the bathroom. And it's just so amazing to me that here, because we're so used to the way it is here, how his the trajectory of his criminal case went from here to here to here, and it doesn't. We don't know where exactly it's going to end unless this is going to be the end of the road for him.
Yeah, I mean, the fact that the original charge was then upped quite some distance into the proceeding, I mean, we don't see that here. It's got to start either with a grand jury or it's got to start with a criminal complaint from a prosecutor.
Right.
I mean, now sometimes we see charges thrown in, but once the point of jeopardy sticks, nobody would dare do it later on.
And apparently they don't have that same double jeopardy standard over there. I mean, typically what happens in a case like this, somebody gets convicted, they are the ones who are appealing, not the prosecution, with the hope that it gets better. It certainly wouldn't get worse. But here, so I'm very interested to see how his legal team is going to handle this latest event.
Right. So what we have, the Supreme Court, who ultimately laid down this double sentence, stated that Pistorius displays a lack of remorse and does not appreciate the gravity of his actions. Do you find that? I found that a little bit odd, especially hearing him on the stand. We heard that it seemed to us, or the viewers, that he seemed very remorseful.
Yes.
I mean, we have to think about it. This was an individual who was a double or is a double amputee. He cannot move very quickly. And then he did state that the area, his surroundings were not very good. So what do you think about that?
I don't know. It seems to be a bit of lip service by the court, because I remember him crying real tears throughout that trial, because I covered it extensively. They certainly seem sincere to me. Not that every defendant cries real tears. Sometimes they're crocodile tears, and we get that. But he did seem very remorseful. So I don't know if the judge was just looking to pigeonhole this and to fit it into a box, because I think the general consensus, especially on the victim's side of things, was that it was a really light sentence for ending somebody's life. But again, like I said here, if it's an accident, then a lighter sentence might be called for, as opposed to if he viciously, intentionally murdered her. And if I'm recalling correctly, I think one of the big factual points in his case was, well, wait a minute, you're sleeping in the same bed. So now before you grab your gun and rush over to a bathroom and start filling it full of holes, why didn't you look over and say, hey, Reva, honey, are you there? Right. And that's what the whole case hinged on.
I have to agree with you there. That's a great point. I think the defense made the great stance during their defense of stating that yes, he was not able to move about his room very quickly. The fact that he was a double amputee, but this just makes logical sense. If you know that your girlfriend is in the home with you, that she was supposed to be in the bed with you, then why wouldn't you just call out for Reba?
And you are protecting her. I mean, part of his defense was he was trying to protect the both of them, but yet he was not aware that she wasn't in the bed. Unless the assessor thought, you know what, I don't think he's telling the truth at all. Maybe he was angry because they had a fight very recent to the actual death, and it was carried over into that night. I don't know exactly how she weighed those facts.
And there's also the element that he was living in an upper scale neighborhood, but a lot of this case fits under the umbrella that it's difficult for those of us who have never been there and never lived there to understand the custom of what happens. And I do have a friend from my distant past who lived in South Africa, and the only thing that I remember hearing is it's dangerous, and it seemed to be a blanket statement that would apply across the board. So I don't know. If you think there's an intruder in your home there, is it the castle doctrine in South Africa? Is that the way people would react? That's hard to answer. And presumably a judge would have a little bit, well, the judge is there, would know more about the way people would respond to something like that in that country.
Yeah, and can they and do they take that into consideration? I mean, how many times do you know where your spouse is all the time in the middle of the night? How many times did Reva Steenkamp get up and use the bathroom prior to that, where there was no incident? So I know there are a lot of questions surrounding it, but again, he did seem remorseful. He sort of fell from grace because his prior transgressions were not anything near the severity of this. And it's incredible to me that this far after a verdict, the sentence can increase twofold.
Right.
Or at all, actually.
Well, what I think, I guess, is kind of odd, I guess just bringing it back to the disparities between our system and the South African criminal justice system is the fact that he is able to potentially have a life once his sentence has been completed. We know at this time I believe he's 30 years old. So by the time that he gets out, he'll be around 43, 45.
Somewhere in there.
Yeah, 43, 44 years old. And so he'll still be able to have some type of a life, even though there was a life that was taken.
Right.
How do you think that, I guess, that does that fare well? Or I guess that's a little bit difficult to say because we're so used to a murderer here, or a convicted murderer, in our case, being locked away for so long, but it's the total opposite.
Well, yeah, I think, and again, the laws there are so different from ours. I mean, one thing that I don't think we do anywhere is we don't increase a sentence based on the youth of the person who's being convicted, right? So here we would have life or life without parole, even the death penalty, but there we don't say, well, we don't want him to get out soon enough to have a life, so we're going to increase the sentence beyond what it's supposed to be. But then again, think about, and I always think about this, what kind of life do you have when you get out of prison on a murder conviction? Like, what do you do? What's he going to do? Is he going to sell insurance? Well, I don't understand what kind of life. It's very difficult to have a life when you have a rap sheet, especially a serious one, following you around, no matter where you are. I don't care what country you're in.
I have to agree with you. That's a good point.
So it's tough. So he gets out at 32, great. Maybe he can write a book. I don't, but who's going to hire him?
Right. I don't think that he'll be able to go back into running in the Olympics. You're right. Maybe write a book. But I know that he had to sell his home in order to pay for some of his legal assets. I know that at this point right now, he's currently imprisoned in Aldridge Correctional Center in the outskirts of Pretoria. The thing that's funny about that is in the correctional facility where he is at this point, it's the max sentences that are served there is 6 years. So now that he has this 13 years, it's probably that he may be moved to a higher security prison. So we'll see what happens if this sentencing stands, whether or not he'll be moved from this low-level security to this high-level security.
Or whether they can fashion some sort of agreement so he can stay where he is, but they just extend the sentence.
Right.
Which could happen, but we'll see. Over there, is, like I said, so far different from here.
Yep. So I think what we're going to eventually go to is we'll be discussing the Holly Bobo matter as well. We do know that last week we had a hearing in the Holly Bobo matter, so we'll be reviewing some of those clips with you all today, just so that we're all caught up to this whole case, so that once the case starts in 2018, we'll be all caught up. What are you thinking about this, Aaron?
Well, it's another one of the hearings. We know Zach Adams was convicted. One of the co-defendants had a hearing last week, and it was another one of these chances basically for the judge just to check the status of the case.
Right.
And nothing monumental came out of it other than another one of these prods from the judge to turn around and say, well, are you folks talking about a deal or a plea or anything like that? And we know that the judge faced a lot of criticism in the first case, the Zach Adams case, for basically saying, if I were the defendant, I would accept my guilt and take a plea. And it didn't go quite that far, so he sort of backed off and just said, I want to see if you are at least talking. But it gave a memory, it resurrected the memory of the original case where a lot of people looked at that and said, look, that's not fair. The judge is supposed to be impartial. The judge isn't supposed to be up there saying, hey, defendant, I think you're guilty and I think you should take a plea, which was the criticism that happened out of the first case. So the judge did ratchet that back a little bit. But just so many shades of the original case popped up, remembering, look, the key witness is a snitch who says he was involved but wasn't involved in any of the really bad stuff. Everybody else did all of the bad stuff. Just trying to watch the defense attempt to concoct a theory about it and falling flat. So many issues with the original trial came up, and that community is going to relive it again when we have other defendants going up on trial. I'm interested to see how the next case gets tried because it's different attorneys.
Right.
Can you even ratchet that back, though? When a judge basically says, I think your client is guilty, are you talking plea deal? I don't know if you can ratchet that back and say, oh, yeah, no, I'm okay. I'm good. It's good. Because that's very prejudicial to a defendant. Even if the defendant is guilty, that's not the point. It's not the judge's place to prejudge anything.
Well, you bring up a lot of the points that I brought up during the Zach Adams case, and I sat here and watched it, and I was just uncomfortable from point A to point Z at the process and saying, wait a minute, that's an issue. The way witnesses being cross-examined was an issue. The way witnesses were being direct examined. You had the state leading witnesses all over the place who then admitted that they had been threatened with family law action by social services investigators. So it's like witnesses, in theory, would have reason to lie because they don't want to lose their children if they say the wrong thing. And frankly, the witnesses weren't saying anything. It was all just coming out of the prosecutor's mouth. And there's a reason why the jury is there to weigh the witness, not the prosecutor's version of the story. So leading the witness all over the place, it sounds like a nice buttoned up story, but I would have really liked to have heard it from the mouths of the witnesses.
And that
was
the
an
judge's
issue.
job. The judge's job is to control that. I mean, excuse me, granted, the defense is supposed to stand up and object. That's why you object. That's why you make a record. Objection and the reason. You don't just let the prosecutor run roughshod and lead the witness and ask all the questions they want without saying a word. And a judge can, even if a defense attorney is not on his or her toes, can jump in and stop it as well. And if you have a judge that thinks everybody's guilty, they're not going to be inclined to do that. And for me, that makes me very uncomfortable too.
And here's the thing. I took a lot of flack online because people are just like, why are you complaining so much about this case? Look, I realize, folks, the defendants are not sympathetic people. They're up there, at least the co-conspirators up there basically saying, oh yeah, there's a lot of drugs involved. And look, I mean, it's a horrific situation, but to me, if we're going to have a conviction, we ought to feel comfortable that it's a clean conviction, that it's a good conviction, that the process worked properly, and we can feel comfortable that the witnesses were telling the truth. But look, every time the defense attorney tried to lodge an objection, a lot of times she got shot down. I don't know if she just reached a point where she didn't want to risk looking foolish in front of the jury or what the tactic there was. If it were me, though, I'd be objecting every time there was a leading question and just keep hammering it over and over again.
Playing to the appeal that potentially is going to come.
That said, I gave myself a crash course in Tennessee law as to this type of issue and many others. And so frequently, the high court in Tennessee is just like harmless error. We don't care the way the witnesses were examined, whatever. The truth came out. Nobody stopped and derailed the proceeding. And again, in other states, would it be enough to at least remand it? I don't know. It just results in a process that left many people uncomfortable.
I have a true story about that. One of my first, it might have even been my first trial, I had a judge take me aside and tell me, and I quote, "Stop objecting so much." And I was, when you're new and you're really wet behind the ears, I was taken aback by that. But then I went back to counsel table and I said, no, if I have to object, I'm objecting. And if there's a problem, we'll deal with it in another court. But you can't silence me. I'm here to do a job. And look, my first trial, maybe I didn't know what the heck I was doing. but I was going to protect the person sitting next to me who was paying me to protect him. And that's what I did. So, but you're right. I mean, it can happen where a judge gives you cues. And she didn't do it. That judge didn't do it in front of a jury, but it still, I think, colored the rest of the proceedings.
I have my evidence professor ringing in my ears, and he said, after a career in defense work, that the way the evidence comes out, the rules of evidence, the objections, that's really where people sitting in the defendant's chair know that they have rights that are being protected. That's what, to them, fairness looks like. That it's fair that some things get in front of the jury and that it's fair that other things, whether or not he spit on the sidewalk when he was 2 years old coming out of the candy store, that just doesn't get in. And that's how the person sitting in the chair knows that he's getting a fair shake. Now, in this case, we had all kinds of random things coming into the Zach Adams case. We had, just a lot of side accusations. I'm trying to remember them off the top of my head. You've got the one where there was some sexual misconduct that was just sort of slipped in, and there was this icy glare, and just the whole thing just raised a lot of questions as to the way evidence should be presented.
Yeah, and again, I think the judge ultimately controls those shenanigans, and I don't like shenanigans. I'm with you. Let's get a clean decision, whether it's guilty or not guilty. Let it be bulletproof. Play by the rules, because we don't play by the rules, and what's the point in having rules? And then before you know it, somebody is getting a double sentence down the road here. We don't want that to happen.
Well, isn't that what the judge's job is supposed to do, or is supposed to be, when we have the jurors that are becoming the trier of fact in a criminal case? The judge's job is to move the case along and to be impartial. He's not supposed to relay any type of guilt or innocence on behalf of the defendant. He's just supposed to move the case along. So that happening is just not a very good look for this judge.
No, and you're not most especially supposed to do that in front of a jury. Now, I've been in plenty of sentencing proceedings where there is no jury present, and a judge will say what is truly on his or her mind. And I often disagree with that too, but it's on the record. But once it's time to impose sentence and you don't have a jury staring at you, I suppose a judge, they're people too. And they can say exactly what they think. And they've heard all the evidence at that point, and they've made their own decision when it comes time for sentencing. But it's so funny because as you know, I was here last week, we were covering a trial where the judge, her face said it all. Like, she didn't say a word, but her face was like, no, I don't believe a word that's coming out of this person's mouth. And that's something too that you have to be careful of, because jurors see your expressions. There's actually a jury instruction that says don't take any sort of cue from the judge. No matter what, if the judge is yawning, sneezing, looking bored, looking like he or she doesn't believe, you're not supposed to take a cue from the judge in those situations. Do the jurors listen to that? I don't know. We're all people, right? I'm going to give the judge a side eye and see what he or she's doing if I'm in the jury box, just to see, are you confirming what I believe, judge, somehow silently? And I think they do that. Judges should really be stoic, I think, more often than not.
Right. So what we know in this case that it's Dylan Adams won't face the death penalty in the Holly Bobo case. What are we thinking about this? Because I know Zachary Adams did face the death penalty. Am I correct?
Yes.
And so
he backed out of it at the last minute by basically copping a plea right before the penalty phase.
Right. And so now the prosecutors have stated that they will not be seeking the death penalty. Can we find them any reason why? I mean, because they are claiming that he was a part of this horrible crime, the murder of Holly Bobo. So any reason why you think the prosecution in this case would not seek the death penalty against Dylan Adams?
I mean, it could be a number of reasons. It could be because they're not sure that the case is as strong as they think it is. It could be because the first defendant copped the plea. Interesting tactic, because if Dylan doesn't have to force that decision, he's less likely to cop the same plea that Zach Adams copped. It could be a fear of having a conviction overturned on appeal. It could be that they don't want to put the jury through that much of a lengthy ordeal. This was a sequestered jury that worked weekends. It could be an expense thing. I mean, it could be any of these things. It could be none of them.
It could also be one other thing. And sometimes prosecutors and defense attorneys have conversations in the back room. And maybe they were trying to negotiate some sort of plea deal. And maybe as a gesture, the prosecution could have said, listen, I'm going to take the death penalty off the table. And maybe 3 witnesses in, they might say, you know what, we're going to cop a plea now because we think this isn't going the way we want it to as a defense attorney. That's possible. And they would not be able to do that with the death penalty on the table. So maybe it's sort of a precursor, or it could be all wet and the prosecution just doesn't think there's enough there to get a death verdict, so they're going to take that off the table.
Okay, so what we're going to do is we're going to switch gears a little bit, because at 10 o'clock we are expecting to hear from the Chris Soules hearing. Just to bring you all a little background information about Chris Soules, he appeared on The Bachelorette. He also had his own season 19 of The Bachelor. From what we know about this case, Chris Soules is 35 years old, and he was a former contestant on the reality TV show. He's been charged with leaving the scene of a fatal accident. Prosecutors are arguing that Souls was required by law to stay at the scene of a fatal crash that killed a Northeast Iowa farmer, so officers could speak with him. So in looking at this, I believe he has been charged with this crime, and there's been a motion to dismiss by the defense, and the prosecutors have filed a motion to resist. So that's the hearing that we'll be watching today. So Souls is suspected of driving a pickup truck and rear-ending a Buchanan County farmer. A farmer's tractor trailer, which ultimately killed him. So what happened? He called 911. Right. He reported the accident and then left. And what we know about this is that it's considered a Class D felony out in Iowa. Jonna, have you ever dealt with a case like this or similar to this? I know that in dealing with personal injury cases, most of the time not most of the time, but you are required to stay at the scene unless you're then considered to be, what's the word I'm looking for?
Imperil yourself.
Thank you. Yeah. So have you ever covered anything like this before?
Let me first say that this hearing is crucial because it's what we call a dispositive hearing. I mean, if he wins the hearing, the case is gone. It's done. And the other thing is, the defense here is basically twofold. It's not saying simply that Chris Souls is innocent of leaving the scene. The defense is saying, look, this statute is unconstitutional because it forces a person in Chris Souls' position to incriminate him or herself by staying on the scene and waiting for law enforcement to arrive and then actually speaking to law enforcement. That argument might have legs. So it's possible that the statute could be declared unconstitutional. The second part of it is, think about what he did as a practical matter. He did stay on the scene. He did render aid. He waited for the paramedics to arrive, not the police officers. And apparently the statute there says you have to wait for law enforcement to arrive. And then he split. And of course we know the reason why the prosecution has charged him and have latched on and don't want to let go is they think he's actually getting away with driving while intoxicated, because there was some indication there was a beer or some sort of alcohol containers in and around the scene of the accident. But they'll never be able to prosecute him for that because they didn't test his blood at the time. So if it came about that he had been drinking ahead of time, he's getting away with that part. I'll put that in air quotes, which could help explain why prosecution is saying, I am not going to let this go because I think you got away with a lot worse. He would be subject to a much higher sentence if the victim died because he had an accident that was due to alcohol.
I'm not sure that I agree with the way the defense is slicing and dicing the statute in Iowa, because look, the bottom line is the statute says you have to remain at the scene except to render aid or report the accident to law enforcement. And one of the things the defense is trying to say here is, well, he did report it, he rendered the aid, and then he should have been able to leave, but I don't read the actual letter of it. I think that's a twisted way to read it, personally.
So you think the statute is constitutional as written?
Well, there's two different issues. One is that they're arguing that he did what it said, and then in the alternative, he shouldn't even have to live under that rule in the first place. They've got two prongs to this.
It's a 1-2 punch. And if the statute actually uses the word or, then it does seem like Chris Souls did what he was supposed to do under the statute. So if they lose the constitutionality argument, he still could win the second one.
Well, here's what it says. If the accident causes the death of a person, all surviving drivers shall remain at the scene of the accident except to seek necessary aid or to report the accident to law enforcement. Now, it seems to me that the only way you can leave, let's say you're driving through rural Iowa. Okay, here's the simple answer that we all know the conclusion to. If you're driving through Iowa, you're involved in an accident, you've got no cell phone service because there's not a tower nearby or whatever, then you can leave the scene to go get help to come back to it. That's the way I read that. To turn around and say, oh, well, once you call 911, you can take off. I don't read that way, but that's one of the things that they're trying to argue.
But look at it, so let's take it to a different level. So let's suppose, hypothetically, Chris Souls stays at the scene of the crime because you have to pursuant to the statute. The cops show up, but then Chris Souls says, I ain't talking to you.
That's Yep.
So then you're still in the same position. You're not assisting law enforcement with their investigation. You probably don't have to, because you most likely have a Fifth Amendment right to not say anything.
Okay,
so
no
harm, no foul.
how would that go? How would that play out? And we're having another one of these lawyer arguments here, folks. I hope that you're enjoying it. How would this play out if he says that at the scene, and let's say hypothetically that he smells like alcohol? You know what they're going to do.
Right.
They're going to try to do a breathalyzer.
Right.
If he says no, I won't let you.
Right.
Well, then he loses his license. Then they're going to call up the judge, get a warrant right away, and they're going to truck him off to the hospital. They're going to do a blood draw, and then we're going to be in an entirely different constitutional realm, because the Supreme Court's all up and down on the constitutionality of that.
Right.
But look, I mean, the problem here is they couldn't even get to the guy to get him out of the house. So first they had to find him, then they had to get the warrant to try to get into the house, and at that point, a million hours go by. I'm sure that the local law enforcement agency is probably talking to the judge saying, hey, look, we need to get a hold of you faster in order to get warrants to go in after people. But so much time had passed at that point that any evidence of drinking and driving had dissipated.
Right.
Well, should we take a look at this or this statute in order to consider the fact that it's there, or maybe the legislative intent was to allow for a proper investigation to be made? Because as I'm listening to both of you all speaking, and I'm having like, I'm agreeing with both sides.
Yeah. We're going to put you on a jury.
I would love that. As a matter of fact, I have to go for jury duty, but I know they're never going to pick me. But anyway, that's neither here nor there. But if you're taking it from Jonna's perspective, yes, there may be some type of a Fifth Amendment issue if he's required to stay there and required to speak. But then on your hand, in your position as well, I understand where you're coming from, and I understand the argument that you're making. But I have to look at it in the fact that now a part of the investigation is incomplete, because we don't know if he was under the influence. And then at the end of the day, someone has died here. So do we know that the reason why he died was because you were under the influence of alcohol, and that's the reason why, so like there's a whole lot in this investigation that's been left unsaid. And so I can kind of understand why the prosecution in this case is so adamant in bringing this charge.
And sometimes that's the way the cookie crumbles. Sometimes you're just not, as a prosecutor, you're not able to prove what you think, what your theory is. And let's add one more hypothetical element to this. What if it's a non-fatal accident?
Right.
All right, so let's suppose, but it could be almost as horrible. You hit somebody, they're alive, you leave, they're paraplegic for the rest of their life, or some horrible accident. You're not then going to be cited with leaving the scene, because the statute only applies if somebody is deceased at the scene. It just seems like is it a poorly worded statute? Could they fix it up there in Iowa a little bit so we don't have these arguments? I don't know how often this scenario actually happens out there, but I actually think Chris Soule's team has two good arguments to make at this hearing today.
Well, if I'm not mistaken, there's another, I'm assuming, and I'm trying to remember because it's been a number of months since I've read all of this, but there's another prong of the statute for if it's an accident, but it's not a fatality,
Non-deadly.
it's a lesser penalty, I think.
So if you leave, you're still in trouble, but you're not going to go to prison.
If you leave and it's a fatality, you're in worse trouble. I think, if I'm remembering it properly, that's the way it went. In other words, you ought to be on notice that if it's a fatality, if there's a dead body on the accident scene, you should say, if I'm remembering it properly, that's the way it's written. Now, I've got to go look it up here in just a second to make sure I'm remembering it properly, but I think that's the way it went.
And we can verify that. I also think it makes a difference, and it would make a difference to me if I were in the jury box. If Chris Soules had this accident, a man is severely injured and dying, and then he just beats feet and leaves and maybe calls 911 later on, that to me is different than staying there and waiting for help to arrive, even though it's not the help that's set forth in the statute, it's the paramedic. That makes a difference to me. Because the paramedics could have easily, if there were alcohol, we don't know these facts yet. If there were alcohol in his breath, they could have smelled it too. They could have provided that information to law enforcement. So it lessens the severity of what he did. We all know, the three of us, if you have an accident, you're not leaving until you know that the last person's in the ambulance, and you're doing what you got to do as a citizen, as officers of the court. And we're officers of the court 24/7. So we're going to do that. But the average person, I don't expect them to act like officers of the court would 24/7. They're human beings. At least he stayed until help did arrive.
Yeah. That's true. So I guess we'll see what happens when we tune into that hearing in about 13 minutes. It's supposed to start at the top of the hour at 10 a.m. and we'll be sure to bring you the live stream from the courtroom as soon as we get back to it. So what we're going to do now is, in the meanwhile, we will start showing you some clips from the Holly Bobo matter. So stay tuned.